Hi, welcome back to La Belle Vie. So it's Monday morning, and what do we have on the docket for the Sarah Boone case? We have another letter from our favorite defendant. So I'm going to go through it real quick right now. It's quite interesting, and I'll provide some takeaways at the end. So let's go ahead and get to it, shall we? Okay, so this was she wrote this on 5/15. It looks like it was received by the court on 5/18. I checked the docket. I don't know that I checked the docket Friday because so it could have been uploaded Friday. But it was definitely there this morning. So here we go. It's written to both Judge Wooten and her attorney and the whole wide world, guys. It's all of us. We are getting a letter from Sarah Boone. Anyway, she gives us a little lesson in the beginning on perspective and gives us the dictionary of perspective from the Merriam Webster's dictionary. I wonder how many people are going to actually look up the definition to see if it's the same. I wonder also how many website hits the word perspective will get. Definition 1. The science of painting or drawing so that objects represented have apparent depth and distance. 2. The aspect in which a subject or its parts are mentally viewed, a view of things, as objects or events in their true relationship or relative importance. Please review so everyone has a clearer, better understanding of my continued concerns, hindrances, questions, and frustrations with the quote, justice system and the solid, absolute remissness of my case and the due process of I am and have been waiting very patiently and maintaining what I can since no one else has or will, it seems. And I feel at this point, 6 attorneys later, linking my video on this and this continued manipulation, I feel like, with the 6 attorneys. She's had 2 actual real attorneys. The others didn't do work on her case because they were conflicted out. That being said, I do think that this is also showing some frustration with the working relationship with our current attorney. But in any event, that just annoys me when I keep seeing that reference. But anyway, 39 months, almost 3.5 years, which is true, which I will make and not by choice. I need to make all aware of my immense struggle with the extreme mismanagement of my case to date. Let's look at the bigger picture or perspective to get a better view of what I've had more than enough time to see and realize. I'm hoping by doing so, eyes can finally be opened and very overdue, long for progress and finalization can be had. The growing amass of ignorance, manipulation, slander, and advantageous gain must stop. My truth needs to be heard, and it is my right. Do not give me do not give me rights expecting me not to fully utilize them. I voted for the president and governor while here in jail, and stop violating what I've been trying to utilize or lessen the value of my capabilities and opportunities. I am not apologetic in any way for being an observant, hardworking, above average, non stereotypical inmate. I can only imagine, sadly, how others not as outspoken as myself have been and are being mistreated, overlooked, and dehumanized. Get it together. Okay, so here we go to the judge, Judge Wayne Wooten. At what point do you evaluate and intercede in a case to make sure there is proper advancement, regular communication between the attorney and client, ethical treatment of client is being upheld, timeframes are being met, etc.? Clearly, you know of and have known of the prolongation of my difficulties from your comments regarding my letters, but with no intervention from you to change anything for a better, less problematic process. You've told me in the past when I've tried to voice my legitimate concerns to you in the courtroom 5 times total in 3.3 years, and in my letters to save it for my next attorney, if told anything at all. I don't know that a judge would have said save it for my next attorney. Do tell, Your Honor, which attorney? I don't know. I will say this will be in my comments in the end. This has got to get taken care of because she's creating this record that looks like she's not having communication with her client, which may or may not be true. But I think the court at this point needs to set a status hearing and get this together. I don't think we should be waiting until July. I'm on my 6th, who I've not seen in person for over 3-month period, 12 weeks, 89 days, and counting. Frank J. Bankowitz has been appointed as my attorney by the court to, quote, represent me in my case, and has been for 10 months and counting. Total approximate hours of quote representation 7,200. Total times attorney met with client Sarah Boone 6. Phone numbers given to client by attorney 2. Phone calls answered from a client by attorney 0. Outside sources calling attorney on behalf of client 3. Phone calls, emails, voicemails answered by attorney 0. Letters client sent to attorney trying to communicate 7. Letters defendant client sent to judge trying to communicate animate attorney in unsuccessfulness 5. 15-minute video visits between attorney and client 3. Attended court date scheduled 2. I was an attempted withdrawal. The other an allowance to finally be included in my PTC, which was the same information carried over from all the others. Now what? 2. Why are you enabling my constitutional rights to be continuously violated? History lesson for everyone. I think this is pretty rich because, as you'll see, some of these amendments don't have anything to do with anything. In her case, First Amendment. How has her First Amendment rights been violated? Fourth Amendment, unreasonable searches and seizures. She's already been arrested. Fifth Amendment, the right to not self-incriminate oneself in trial. I don't think that's happened yet. Sixth Amendment would be right to due process for criminal defendants. That could be potentially applicable. Eighth Amendment, cruel and unusual punishment. I don't think so. 14th Amendment is due process as applied to the states. That would be potentially applicable as well. So anyway, I just find it rich that she's giving us a lesson, but in any event. Why am I being, quote, judged for my legitimate letters I write in order to know the status of my case or attorney and how much longer before something substantial occurs in the progress of 3.3 years later, other than the inappropriate prejudgments being made due to the excessive amount of my case information online, bigger and meaner fabrications of my case-sensitive details in which I have not seen, or even greater mind-numbing one-sided ignorance. If I didn't write my letters, would you or anyone be aware of all my rightful concerns still and ongoing? Is a perpetual question mark over a defendant's head the norm during a case due to inactivity, no communication, no help or intervention, or answers being given by anyone in the, quote, justice system? Honestly, what has been done about or with any of my letters other than being scanned, uploaded incorrectly? I made sure to correct so everyone is up to speed on my case status. Unfortunately, is all I have to report at this time. This is where she does not understand the Freedom of Information Act and the Florida Constitution on open access to courts and public records. She doesn't get it. Why are you allowing numerous case safety and protection elements to be breached, violated, manipulated? Why has a gag order never been implemented? My case is turned into an unnecessary, quote, witch hunt from the innumerable violations of my case details being leaked and racketeered illegally in exchange for website hits, viewer ratings, etc., in exchange for money. What is your cut, Your Honor? You choose who knows what, where, and how in your courtroom. When do the court minutes become live? Are you the one who authorizes the upload to the internet? It's all about how much rather than how did it happen. No matter the destruction caused in the meantime and is irreparable, it's not even about the suitcase anymore. My case is now a global event with the video receiving over 3 million hits, depending on the website, in turn making me realize that's over 3 million less unprejudiced, unbiased, non-discriminatory, fair jurors I will have access to on my case. How is that going to work? Now what? Factoring important private details. Again, these are not private. The state will protect your private information. This is all public information. Should not be made readily and available for the world to know about before I, the defendant, does correct. This is wrong. Now, I mean, her lawyer should be sharing case updates with her. That's true. And we don't know that that's not going on, but I'll give her that. This is wrong, unconstitutional, unfair, and not how justice is supposed to work for anyone. I'm tired of having motives attributed to me that are unreal, assumed, and inappropriate. This is not legal. This is what a trial is for, correct? At this point, what can even be rightly suppressed in my case? Once you ring the bell, it cannot be unrung. It's already been heard and seen. I don't even know where the bell is or who's ringing it. When do I, the main component in my case, actually get to know, see, hear everything else everyone else has? When am I going to be included also? When is the next status hearing you stated would happen before my pretrial conference 7/11/23? My attorney's 1 year mark. Am I included? Well, she should be included. And as I just mentioned, that's one of the things I think the court's going to need to get on the docket is a status. And the judge said that at the last hearing at the end of March. So what else can I do to ensure the productivity, communication, incorruptibility, appropriation, and intellectualism of my case? It is my right to know so I can begin or continue for true progress of any kind to finally be succeeded. Okay, so that was the words she had for the judge. Now's the words for her lawyer. Attorney Frank J. Bakowitz, where are you? Our last in person was February 15, 2023, 3 months. That might be true. When is our next meeting? Remember, please, there are still time sensitive matters pressing. FYI, in the 10 months of your representation, here are the 6 meeting dates which have occurred so you can see prospectively the massive time gaps in between work while I've been sitting eagerly waiting, wondering. All I can say about that is I've done a Florida public records search, and one of the things that you can get as public records is call logs and visitation logs. And there were 4, unless these public records are wrong, there have been 4 meetings, not live, but meetings that were logged in as internet visit, so to speak, in March and April. And my public records request only went through part of April. So unless she's talking about in person, I don't even know that this is not jiving with the Florida public records. So that's why I say, this is what she's saying, but, we're not hearing obviously from her lawyer. It would not be appropriate for him to comment, which is why I think we need a hearing at this point to get some of this stuff kind of resolved. Okay, why aren't you fixing either of the 2 phone numbers you gave me upon your appointment back in July 11, 2022? Every time I ask you about it, it's a different excuse. Much progress can be had in a very expeditious manner if completed. Why has it not almost a year later? Why do you keep telling me to call when you know they don't work? As I said before, public defenders answer their calls and reply to mail. Why are you unable or unwilling? See the difference it'll make. So again, I think that's where the court really needs to make sure that there is normal communication going on between the court-appointed attorney and Ms. Boone. I agree with that. I think and again, we don't know the whole story, so I think that a status conference is definitely would be helpful. Our agreement made from one of my letters I wrote earlier this year after not hearing from you in a solid 5 months prior was to connect every 2 weeks with or without any significant progress. Why have you not been upholding this agreement, even in a 15-minute video visit? Remember, a phone call is another option and not as difficult technologically. A working number is needed, just one. What are your anticipated dates of completion for anything already discussed and will eventually, when you do actually show up for an in-person scheduled meeting? There are 1,000 little fires needing to be put out. You're holding the fire hose. Please see from my perspective that botched, eye-rolling experience I'm going through still, and how I believe anyone would act or do in my sides doing the same. What would you do? Do not fault me in trying to make the best, most successful outcome possible for myself in every aspect in the convoluted predicament I am in and have been over the last 3.3 years. I'd rather be called a narcissist, pain in the behind, arrogant, strange, or whatever else anyone wants to waste their time to think of. Just don't call me a murderer, which I am not. No one knows me except for the ludicrous insanity that's been made up, mocked, edited, and spewed all over the internet. It's not me. The only thing that's on the internet is public information, including your interview. I'm hoping and praying my highly anticipated day will come, whenever that will be. It's God's timing. I continue to wait smiling. Oh, that's good. At least everyone will know I'm not sitting around eating bonbons. No, honey, you're not. Watching soap opera. Application is the product of the lesson. Give me my chance appropriately, correctly, and fairly in court. Unfortunately, my perspective of our justice system is incredibly dim and dull. I hope my very overdue blinding light has shone brightly for all to see a glimpse of how it really works. And being a system, we all have to work together to function in unison. Please help see the difference I'm trying to be and make. Waiting and wondering, keeping it real. Now what? Sarah Boone. So my takeaway is uh clearly there's still some communication going on. And this doesn't help. It kind of shows that there might be something that's going on when there might be nothing going on. Things might be moving along, but I think that the court should have a status hearing to kind of nip some of this in the bud and see what's going on. So there we go. Thank you again for joining. Just wanted to get this one out there real quick. It's never a dull Monday when you've got a letter from Sarah Boone. And if you would consider liking and subscribing, that'd be great. And I hope to see you on my next one. Bye.